Hudson? You can't get his audio started? Okay. And we can't get Hudson to start his, that's his, who's his attorney? Well, what, you can't call his client?
Thank you.
Good morning, Your Honor.
Good morning. Do you have your client's phone number?
I do. It is 517-719-7302.
Okay, can you call him and tell him to start his audio?
Yes.
Thank you.
Your Honor, I called the number I have, which is his wife's, who's not there. He was having a little, she helped him last time because we went to the other presiding judge's matter. I mean, we're simply just adjourning the PCC. I know you probably want a waiver on the record, Your Honor, but he's having, I don't think he's very tech savvy.
Yeah, it's quite evident. He probably doesn't know. It looks like he tried to start his audio, but that he's not.
Yeah, he's having some trouble. I told his wife that she's just gonna have to be there at the next hearing because we can't have these kinds of problems. But I did discuss with him about waiving the 21-day rule, Your Honor. I do have permission to do that to adjourn this out to get some discovery. If the court would allow me to waive that on his behalf, I'd ask the court to give me permission to do that, Your Honor.
Okay. No, I'm not gonna allow you to waive it on his behalf. I want to make sure I hear from him that he understands his rights as it relates to that. But I will note here on the file that we'll treat next week as a PCC, and then you can do that before Judge Ward. How about that?
That's fine, Your Honor.
Okay. Okay, so we're all set on that one today then.
Yep. Thank you, Your Honor.
Morgan. These ones that are crossed out, I'm assuming we're already taking care of.
That's what Mr. Graves.
Okay, so we're just waiting for Morgan. We're on the record in the matter of the people of the state of Michigan versus Jordan Caleb Yu, file number 20-00439. Councilor Chance.
Brian Ring on behalf of the people practicing under Michigan Code Rule 8.120.
Thank you, Honor Dale Coulter, appearing on behalf of the defendant who's standing in my lot.
How are you, Mr. Yu?
How are you?
I'm doing well, thank you. Okay, today's the date and the time set for a preliminary examination. I have a plea sheet here. It says the people are offering for you to plead to an added count 2 of larceny 200 to 1,000. And there's no objection to sentencing under HYTA, and the people will dismiss count 1. That's an accurate understanding of your plea offer, sir?
Yes, ma'am.
Okay, you want to accept that offer?
No.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Ma'am.
Okay, put your hand down. I do have a advice of rights and plea information sheet here. That's today's date on it. Did you read this?
Yes, ma'am.
You understand the rights listed here?
Yes, ma'am.
You know why these are crossed down?
Yes, ma'am.
Why are those crossed out? I'm sorry?
Sign the paper with the plea deal. So all them, once you cross out, doesn't apply to the actual song.
Oh, so you're saying that's to indicate that you're waiving those?
Yeah.
Okay, I just wanted to make sure I'm on the same page, because those are still rights that you have, you would waive them. Okay, and that's what you want to do?
Yes, ma'am.
Okay, so you understand that you had the right to have a trial on this matter, and that you had the right to the presumption of innocence, and that you're innocent until the prosecution can prove you guilty. And you have the right to have the prosecution bring sufficient evidence to prove each element of the charge being brought against you. They have to bring enough evidence to prove your guilt beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to see, hear, or question any of the witnesses that prosecution intends to call. And you have the right to call your own witnesses or present evidence you believe would further defense to the charge. You understand all of those rights? And you're freely and voluntarily giving those rights up today? Anybody threatening you to get you to waive those rights?
No, ma'am.
Any promises being made to you in exchange for you giving up your rights?
No, ma'am.
Are you currently on probation or parole?
No, ma'am.
You understand that a guilty plea can result in a conviction that you may need to report to either your current employer, or you may need to report a conviction on a future job application. You also understand that a guilty plea could have impact on any immigration or travel status you may be seeking. Are you entering a guilty plea because you believe you're guilty?
Yes, ma'am.
Okay, as to the added count 2 of larceny 200 to 1,000, how do you plead? On a factual basis.
Yes, I can do that. Sir, I'm going to take your attention back to January 23rd, 2020, at the location of 5510 K North. That would be in the city of Lansing, County, Michigan. At that time, would it be a true statement to say that there was an individual by the name of Kirsten Bankston, and that you took her phone without the intent of returning it?
Yes, ma'am.
And would you agree that the value of that phone was between $200,000? And you understand the nature of this plea today?
Yes, sir.
And you understand there's no objection to HIDA, but if you were not to complete probation successfully, if you were granted HIDA and you did not complete that successfully, this charge could end up on your record. You understand that, correct? You would like to go forward?
Any questions from the people?
No questions, thank you, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Sentencing date's going to be April 14, 2023 at 8:30 in the morning. That can be via Zoom. Prior to sentencing, and actually when you leave the courtroom today, you need to go downstairs to the probation department so that they can get you set up for your pre-sentence interview, okay? Do you have any questions today? Any additional matters for the record, counsel?
Nothing on behalf of people, thank you, Your Honor. Thank you. Have a good night.
Miguel Castanon. Mr. Mr. Mills is not here.
I saw Mr. Milks outside earlier, Your Honor.
Timothy McGovern was already nolly.
That's what I'm aware of. Mr. McGovern was nollied already, yeah.
Yes.
Okay. Is he here?
He was cut loose.
I did not cut him loose, but he was cut loose. And he was informed that the case was being dismissed.
Okay, we don't know where Mills is right now. Austin. Mr. Goodrich is present. We're on the record in the matter of the people of the state of Michigan versus Taisha Monique Morgan, file number 23-00397. Council appearance.
Good morning, Your Honor. Jennifer Lott on behalf of the people.
And Luke Goodrich from the Public Defender's Office here to represent Ms. Morgan, who's also appearing over Zoom today.
Okay. Ms. Morgan, can you hear us?
Yes,
Thank you. Today's the date and the time that's set for probable cause conference. I have here a complaint. There's a count 1 of identity theft, count 2 financial transaction device possession of fraudulent 1, and count 3 police officer assault resisting and obstructing. This matter is scheduled to have a preliminary examination on February 24th, 2023 at 8:30 in the morning before Judge Cynthia Ward. Are we continuing to exam?
Yes, Your Honor.
Okay. Any matters that we should address today while we're on the record?
Nothing from the people.
No, Your Honor. Thank you.
Okay, fine, we'll continue. And Ms. Morgan, you need to appear in person for your exam next week, okay?
yes,
Okay, do you have any questions?
no,
All right, you're all set. Thank you.
thank you.
Thanks.
Your Honor, where's the hospital called Christopher Williams?
We're on the record in the matter of the people of the state of Michigan versus Christopher Williams, file number 23-00235. Council appearance.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Jared Austin, appearing on behalf of Mr. Williams, who is making his way to council tonight.
Okay, today's the date and the time set for preliminary examination. I didn't have a note here. We were treating today as a probable cause conference, is that correct?
That is correct, Your Honor. The reason for that is Mr. Williams has another case pending with my office with the same victim. To be clear, it's not something that is alleged to have occurred while he was on bond. It simply took time for our office to get the warrant request and process it. I signed the complaint last week on the 9th. I was informed yesterday it was taken to Judge Buchanan. I spoke to Judge Buchanan this morning. It was taken her at 2:53, very much close to the 3 o'clock cutoff. There was a slight issue with the affidavit that needs to be corrected, and that was sent back to the detective this morning. So we simply need a little bit more time for that to happen. But it is another felony matter with the same victim in the same time frame.
Okay. Mr. Goodrich.
Mr. Austin. Thank you.
I'm sorry, Mr. Austin, yes.
Okay, happens all the time. That is correct, Your Honor. And I've spoken with Mr. Williams about this. Simply what we'd be asking the court to do is to adjourn this preliminary examination out in anticipation that that new file will be processed rather shortly. We can get Mr. Williams arraigned on that, and hopefully we can get the preliminary exam dates synced up on both of those files. I've spoken with Mr. Williams about that. He understands that in order for that to happen, this preliminary examination would occur outside of the 21-day time frame he's entitled to have it in. He's not giving up his right to have the hearing, just the timeliness of it. And he has indicated to me that he is agreeable with that for efficiency purposes.
Mr. Williams, how are you?
I'm fine.
Okay, and so you understand what was just stated by your attorney?
Yes, ma'am.
So you understand you did have the right, or you do have the right to have your preliminary examination within 21 days of your arraignment.
Yes, ma'am.
And due to the pendency of a new case with the same victim and the efficiency and the efforts to further judicial economy, you're willing to waive the 21-day timeline so that that case can catch up to this one?
Yes.
Okay, anybody threatening you to get you to waive the 21 days today?
No.
Okay, we'll get you a new date today, okay?
March 10th and 9
March 10th at 9 a.m.
Have 1 second to check my calendar if I may, Your Honor.
Oh, absolutely. Mr. Austin. I swear I know who you are. I just, Mr. Good was just the last person on the Zoom. Messed me up a little bit.
Pretty sure you called me Brian last week.
Who, me? I didn't call you Brian. Never happened.
Like to think I look a little older than you.
I have a trial that is set to begin that week with a visiting judge that may likely go and it may spill over into that date. So if we could get another day or another week.
No problem.
March 17th
That would be
17th?
fine.
Okay, at what time?
at 9.
March 17th at 9 o'clock in the morning.
Thank you, Your Honor.
Juan will continue any additional matters for the record.
Not from the people.
Nothing further on behalf of Mr. Williams, Your Honor. Thank you.
Thank you. You're all set, Mr. Williams. We'll get you a copy of your notice to appear for that date.
Thank you.
Looks like we're running those. Justin McLean's in custody? Huh?
Yeah.
Running around in the car. Richard Nostrand is going to continue to examine, is that correct? Is he here?
Okay, he was here.
Which matter is APA locking down?
Sounds good to me.
I'm done, I think.
I'm sorry?
I'm done.
Okay. Oh, are you on Zoom as well? Is that what's going on? Someone's on Zoom.
Oh, I probably didn't get on Zoom yet. I can disconnect from
Sonali. Nostrand's continue to exam. What about Ralph White? Do we know?
I believe that's continued. Well, my part, that's continued to exam, Your Honor.
Have you spoken to him yet? Continue.
Justin McLean, there should have been a null, Your Honor.
I just signed it. What are we doing with LaDonte Jones?
Your Honor, I think we're going to waive the exam, go to circuit court. My client's in a wheelchair, so I have him out in the hallway right now.
Okay, sounds good. So, and Messer, Rufus Messer, what are we doing with that?
I have had no contact.
Oh, so he's not here. Where's your bench warrant? Okay. We can bring Mr. Jones in then.
on her way. Is it call her again?
Yeah.
Okay.
We're on the record in the matter of the people of the state of Michigan versus LaDonte DeMarc. DeMarkey
Yes, ma'am.
Jones. File number is 23-00385 FY. Council appearance.
Ryan Ring on behalf of people, President, Michigan Court Rule 8.120.
Thank you, Honor. General Coulter, appearing on behalf of Mr. Jones, who is standing immediately to my right.
Okay, how are you, Mr. Jones?
I'm fine.
Okay, today's the date and the time set for preliminary examination. My understanding is that the parties wish to waive exam today, is that correct?
That's correct, Your Honor.
That is correct, Your Honor. Waiting for further negotiations.
Okay, Mr. Jones, you understand that you have the right to have a preliminary examination today here in the district court. You understand the purpose of the exam? Okay, so the purpose is for the prosecution to meet their burden, which is to establish that there's sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that? Do you wish to waive, and that's an unconditional waiver, your examination today? Okay, so that means that this matter will be bound over without any hearing here in the district court for the prosecution to establish the burden of probable cause. You recognize that? And you understand that the waiver is unconditional. You can't change your mind. Once this matter is bound over, your right to have that examination is gone. You understand that? Anybody promising you anything to get you to waive the exam? Any threats being made to you? Can you waive it freely and voluntarily? Okay, let me get you to sign that, please.
Your Honor, I would just like to put on the record there has been an offer made at this time, plead to the weapons charge, plead to the possession charge with 7-4 months.
That's correct, Your Honor.
Was to plead to the weapons and what's the other option?
And add a count of possession of controlled substance, Your Honor. And the concealed carry weapons, people would dismiss the felony firearm.
Upon your waiver to be made freely and voluntarily, the matter will be bound over to the circuit court. Bind over date's gonna be March 1st. That's the date that the circuit court gets the file from this court. You do not need to appear at the circuit court on that date, okay, sir?
Yes, ma'am.
Your next court date will be in circuit court and it will be a pre-trial. Both you and your attorney will be made aware of that date. Do you have any questions at this time? Bond is set at 5,000 personal recognizance that will continue. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
No, Your Honor, thank you.
You're all set, sir. Let's see. We're running Braxton and we're running Evans and Holmes?
I don't think we're gonna run Braxton at this moment, Your Honor. I believe that Mr. Colbright just told me that they were gonna wait the 21 days.
We're on the record in the matter of the people of the state of Michigan versus Del Rico Braxton, file number 23-00384 FY council.
Brian Ring on behalf of the people practicing our Michigan Code 8.120.
Thank you, under Dale Culture, and bring that against. Braxton, standing immediately to my right.
How are you, Mr. Braxton?
I'm very, how about yourself?
I'm doing well, thank you. Today's the date set for a preliminary examination, and my understanding is that you wish to unconditionally waive your exam, is that correct?
We
Wait 21 days.
Or you're just waiving 21
21
days,
days.
okay. Oh, why are we waiving the 21 days?
There's a couple of discovery items out there that I need to get to Mr. Colbright that I don't have yet, Your Honor, that I'm tracking down.
Okay. Okay, so you have the right to have preliminary examination within 21 days of your arraignment. You were arraigned on February 3rd. And your examination was scheduled for today, but because it looks like some discovery is still pending, I'm not even gonna have you waive. I'm gonna find good cause to go beyond that timeline. Because you should have all the discovery you need to try to formulate a defense if necessary, okay? So we're gonna go beyond that timeline based on good cause. I'll get you a new court date. Do you need a new PCC date or just?
I don't think we need to.
I don't think
March 10th at 9 a.m.
Okay, we'll get you a copy of your notice for that new date, March 10th at 9 a.m. Do you have any questions today?
No, Your Honor.
Any additional matters for the record?
Nothing further, Your Honor.
Nothing we have to bring you.
Thank you. You're all set, sir.
Thank you.
And now we're gonna run Evans and Holmes.
I believe we're running Evans, Holmes. Yes, Your Honor. And then
Austin on here is here. Okay, is Austin available?
saw him just a couple minutes ago. I don't know where he went.
I recognize you were here. I just didn't know if your attorney was available. If not, then we'll start with Evans and Holmes. Mr. Hudson just refuses to. Raphael.
No, we can do drum by sentencing and budget because they're asking for an adjournment.
Who is Raphael?
Raphael White of PCC.
Oh, okay. Mr. White, can you hear me?
Yes, I can hear you.
Did you speak to your attorney?
Yes.
Okay, we're told you're continuing to your exam, so you're all set for today. You need to appear in person for your exam next week, okay?
All right, thank you.
Yes, you're welcome. Who is this?
Mr. Cleggett, Your Honor.
We're on the record in the matter of the people of the state of Michigan versus Ronald Cleggett, file number 22-03491, council appearance.
Brian Ring on behalf of Steel Prices and Michigan Court Rule 8.120.
And good morning, Your Honor. Stephen Mills on behalf of Mr. Cleggett, who is present and standing to my right at this time, Your Honor.
Today's date and time that's set for preliminary examination. How are we proceeding?
At this time, the people will be requesting adjournment. The necessary witness/victim is not here. I have spoken with her in the past. I did call and leave a voicemail, but she did show up to the last preliminary examination that was scheduled when the defendant had COVID and we had to adjourn it to this matter, Your Honor. So I would ask for an adjournment to get into contact with her.
Your Honor, my client indicated that he's never had COVID, but obviously the jail did not bring him over last time, which was a problem since he was not here in person. The people are not ready to proceed to that. I asked for dismissal, Your Honor.
Your witness was subpoenaed?
She was, Your Honor, and she did appear last time when.
Motion is granted. She didn't appear today, so I'm inclined to believe they're just going to reissue the charge against you. You're just going to have to come back in and get arraigned again because I'm inclined to believe they're going to reissue. So it's up to you if you want to move forward and have to go through those steps again.
We would like to get the dismissal.
I'm gonna dismiss without prejudice today. I'm just advising him that they have the right to reissue, and if they make contact with her, the prosecution is indicating he will reissue. Yes, sir.
What do I have to do to get it?
We're gonna hold on, I'll talk about that, so give me a call. That's not our focus.
Yeah, that might be an appropriate question for him. Did you have a question for me, though?
Oh, I
Probably not.
have another charge for like,
Oh, that's,
for,
there's a collections matter. at it.
We owe some money.
While we're still on
Yeah.
this matter, Your Honor, I do have, the people would object to the instructions of records under MCL 764.26A.
They're objecting to the destruction of your arrest record at this time, okay, sir? They're objecting to the destruction of your arrest records at this time.
Thank you, Your Honor.
Any additional matters?
Not on this matter, Your Honor. I believe it's just the collections matter we'd like to address.
Okay, give me just a moment. Let the prison see. We'll get you a copy of the nollie on that one. This is the matter of the people of the state of Michigan versus Ronald Claggett. File number 17-04101. And in this matter, you have a warrant for failure to pay. Says you owe here $2,351.98. Last time you were here, it looks like you saw Judge Ward October 17th. You appeared via Zoom. You said you'd pay $20 per month beginning December 2022. Apparently, you've not done that.
Your Honor, he's been incarcerated on this matter. He just recently bonded out. He was, his initial arraignment, I believe, was December 14th, 2022.
On which matter? The other matter that was just knowledge?
I'm sorry, yes, Your Honor, on that other matter. So he's been in jail, Your Honor. He's recently bonded out. What, last week?
January, because
January
February 20th hasn't come yet.
Sorry?
February 20th hasn't come yet, so.
Yes, that'd be true. So he's recently bonded out, Your Honor. We're just asking, I guess, for an extension or to allow him to have.
It's been out for almost 30 days. You didn't make your $20 payment.
These drops, my back rent, my back bill, they killing me. I already got eviction notice on my apartment.
I'm inclined to believe that you're probably buried in some bills. You're buried in a bill here too. You owe $2,351.98.
Yeah, I can start paying on that right now. I mean, not right now, but
No, you're gonna pay on it. You're gonna start paying on it right now.
yeah.
It's from 2017. How much you paying today?
I pay $20 a day, but if I
Thank
pay,
you.
if I pay
Thank you.
$20 a day, I'm still gonna have a warrant for not being able to pay the drop. I wonder if I can get at least a week
You get a week to do what?
to start paying.
To pay on this one, and then because you need your $20 to go drop on another matter.
Yeah, I'm actually on,
Are you on probation?
no, I'm on tether for this case right here.
The one that's being dismissed?
Yeah. Oh, so I have to take, oh, okay, so I don't have to go back and drop them.
No, you're getting, no, the tether's gonna come off
Oh,
because the case was
okay,
dismissed.
well, I can pay this.
Okay, so you're gonna pay the $20 today on this.
Yeah,
And then you're gonna make payments of $20 per month.
yeah.
Are you working, sir?
I'm not working right now, but I actually have a date for GM, for my orientation coming up.
Well, good luck with that. You definitely need to be working so you don't, you stay out of trouble, but then you don't get buried in bills and evicted. Okay, sir? You have any questions?
No, man.
Okay, you're all set. We'll get you over the window so you can make your payment. Mr. McLean? That was just Nolly, correct? your case was dismissed, sir.
Oh, McLean?
Yes, yours was dismissed. Do you have any questions?
Can you send me some paperwork for that?
We can get you a copy of the dismissal mailed to the prison, okay?
Okay, thank you.
You're welcome.
Thank you.
We're on the record in the matter of the people of the state of Michigan versus Jerome Hunt. File number 22-01597. Council appearance.
Morning, Your Honor. Stephen Phillips on behalf of Mr. Hunt. And change my right at this time.
How are you, Mr. Hunt?
Bless her, thank you.
No problem. Today's the date that was set for sentencing. I think we set this for sentencing because there was a victim and we need to find out restitution. I have a restitution sheet here saying that you're to pay $111 to a Kristen Wright, who's not appeared today, correct?
That's correct, Your Honor.
Okay. And there's no objection to that amount of restitution?
No, Your Honor, I believe that's part of the plea deal.
Okay, sounds good. Want to make allocation?
Your Honor, at this time, we're just asking that my client get an opportunity for probation in this matter. As he explained last time, he is on the right path. He's in faith-based ministries, but faith-based programs, Your Honor, for treatment. He's doing exceptionally well. I'm incredibly proud of him. And I think more importantly, he's really proud of himself. He's really pulled himself up here and we've got real hope for him here. I think the monitoring structure is going to be good for him. And I think it will be different than last time, that he now has a true goal and aim here, Your Honor.
Thank you.
And he is currently employed. I'm very happy to hear that.
Very good. Where are you working, sir?
I'm working out at Woodbridge.
Been there.
I just started.
Do you have any other pending matters, or are you on probation for anything else? I think I discharged you on the other matter, correct? How are you doing in other regards? You staying out of trouble? You're staying off of substances?
Yes, I am, man. My sister is back on me. She's keeping me on track. She got all my credentials. I was able to get a job yesterday. Feel great. But like I got.
You look remarkably different than you did at least a year ago. I'll tell you that.
Thank you.
I'm inclined to sentence fines and costs at this time. Your fine in this matter will be $250 plus you'll pay $111 in restitution. When can you make payment?
First paycheck.
When is that?
A couple weeks. I think they hold back the first moment.
How about this? You'll pay within 30 days?
That's fine.
Okay, any additional matters for the record?
No, Your Honor, thank you.
Nothing from you? No worries. All right, good luck to you, sir. Stay on the
Thank
good
you.
path. Have a good one.
Thank you. You too.
Are we ready on this exam?
I am ready. Your Honor, I'm done with you. Yeah. I'm done with you. You're done with me, or am I done with you?
Look on me, look on me.
Oh, yeah. You should get the app.
That's not.
It's not for this cup. We're waiting for her computer to restart.
I didn't know if we were waiting.
Oh, yeah, her
I didn't know if we were
computer.
waiting on me or anything, because I would.
No, her computer
I'm ready.
glitched out.
No worries.
Okay. We're on the record in the matters of the people of the state of Michigan versus Adrian Evans.
Yeah. Mr. Evans.
Okay, and then is it Wardell Holmes? Okay, very good. I have file number 23-00349 for Evans and 23-00350 for Holmes. Council appearance.
Brian Ring on behalf of people practicing under Michigan Code Rule 8.120.
Thank you, Honor. Gail Colstrader on behalf of Mr. Evans.
Jeffrey Ross, on behalf of Mr. Holmes, is standing to my right.
Thank you. Today's the date set for preliminary examination. Are we ready to proceed?
We are at this time, Your Honor.
Your Honor, I had two slight matters.
Yes.
One, I would request that all witnesses are sequestered prior to the examination. Two, I guess at this point, I'm going to object to this examination being held jointly. It's my understanding it'd be the intent of the prosecutor today to amend this charge to a day prior, that my client is guilty of carrying a concealed weapon on the day prior to this. In fact, I think the people are acquiescing that he did not have a weapon at the time that he was taken into custody of Mr. Holmes. We would stipulate to that Mr. Holmes had a gun. My client didn't have a gun. He was taken into custody.
I'll let you respond because I have no idea why these are being done together.
That is correct, Your Honor. At this time, we would be amending the complaint against Mr. Evans to the day prior,
The day prior, what's the date?
January 30th.
That's what the complaint says.
Didn't say the 31st.
It says January 30th, and his says 31st.
Oh, well then, never mind, Your Honor.
So
I would still have a standing objection. Your
I'm
Honor.
trying to
I don't know.
understand what's going on.
The witnesses, Your Honor, I don't have an issue with severance either, Your Honor. I don't object to it, but the witnesses were tied together. But I have one witness for one case and one witness for the other case, and neither are going to testify on either each other's case.
Okay, so this was not filed as co-defendants, correct? Or was it? I don't see that. It is filed by co-defendants.
Yeah.
It doesn't sound like he has any objection to your objection, so it sounds like you're stipulating to sever them, correct?
That's correct, Your
All
Honor.
right, well, we can take the first one and keep it moving. Who do you want to do first?
Your Honor, if these cases are going to be severed, my client is going to waive policy once the co-defendants are going to.
Okay, so he wants to waive his,
Yes,
okay,
and then we have a bond issue we want to discuss.
okay. So we'll take his matter, Mr. Holmes. You understand that you have the right to have a preliminary examination in this matter? You understand the purpose of the preliminary examination is for the prosecution to meet their burden, which is for them to establish that there's sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime? Okay, you wish to waive that exam unconditionally today? So you understand that that means that you can't come back later and decide that you want to have the exam. Once you give up that right, this matter is bound over without any hearing here in the district court to establish probable cause. You understand that? Anybody make any threats to you that you don't want to waive your exam? You're waiving it freely and voluntarily?
Yes, Your Honor.
Bind over date will be March 1st. The prior date you need to appear in court, that's the date that the circuit court will get the file from this court, okay?
Yes, Your Honor.
Your next court date will be a pretrial. Both you and your attorney will be made aware of what that date and time will be. Do you have any questions today?
No, Your Honor. Thank you.
Okay, and there was a bond motion.
Your Honor, it's my understanding that there's no contact order in this case, but my client can't go back to his apartment. I believe that was done because this was a co-defendant case, and the co-defendant had some issues with the people in the apartment complex. I don't believe my client had anything to do with those issues. It is my understanding that on our date, the person who was there doesn't even work for the apartment complex anymore. We're just asking that he be allowed home and be allowed to have contact with his partner. I don't think there's any objection from the prosecutor on that.
I'm not, yeah, it says no contact with 3200 South Washington.
Right,
What's that mean?
And he's correct on it. Mr. Rossini is correct on everything you said, Your Honor. The plaintiff victim doesn't work there anymore anyways. That people have no issue with a modification of that.
And you're right, Your Honor, I don't understand that.
And I don't know how like that.
And that's your address, correct?
Yes, ma'am. Yes, ma'am.
Okay, motion to amend the bond is granted. Any additional matters for Mr. Holmes?
Nothing we have to do. Thank you, Your Honor.
Nothing, Your Honor, just that bond be continued.
Bond will be, all the other bond conditions will be continued, and I'm gonna have him sign this waiver. as well. Okay, we're ready to proceed on Evans.
We are, Your Honor.
Your Honor, I'm sorry, he has a tether, and so I guess he has to either.
I can't put someone.
have-
Was that tethered for him not to, for the 3200?
My apologies.
I'm not following what happened here.
People have no objection to the waiver. It is either. I just told you. I didn't really have that either.
Okay, we'll remove the GPS tether. Man, what's going on at 3200 South Washington? Okay, that's it. Okay, and so sequestration order is granted. Where's your witnesses?
He's sitting right outside, Your Honor.
There's only one witness.
There's only one witness, Your Honor.
Okay, any additional preliminary matters? Okay, you can call your first witness.
People call Gavin Royston.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, can you have a seat there? I need you to keep your voice up pretty loud too. We got fans running in here because it's really warm. There's a microphone that's in front of you. The lady that's directly behind you is my court reporter. She has to take down everything being stated in the court. And so all of your responses must be verbal, okay?
Right.
They must be loud and clear. You can't do head nods or shakes because she can't write that accurately into the record. If you don't understand a question, you can ask to have it repeated, or you can say you don't understand it. You also want to make, if there's an objection, you want to stop responding and allow me to make a ruling on that objection. And then I'll tell you whether or not you can give that answer or not, okay?
Okay.
Can you state your first and your last name and then spell them both?
My name is Gavin Royston, GAVIN-ROYSTON.
Counsel, you can proceed.
Thank you, Your Honor. Gavin, where were you working back on the 30th of January of this year?
I was working at 3200 South Washington Avenue.
Is that in the city of Lansing, county of Ingham, state of Michigan?
Yeah.
What capacity were you working?
I was just a security officer.
And was that for an apartment complex?
Yeah.
How long did you work there?
Couldn't have been, I worked at a few sites. I worked at the Abbott, and then I got moved over there because a full-time position opened up. And it couldn't have been probably a month. I worked at that building, month or two.
And did you work at one point with an Adrian Evans?
Not with him. He came in on off the shift change. At 11, and I would leave at 11.
Okay. And so we're gonna go back to January 30th. That evening, can you tell me a little bit about what happened that evening on January 30th?
January 30th, was that the night before the police were called?
That was January 30th that evening. Do you remember? Do you remember what happened?
I remember opening the door for Adrian Evans. I remember saying, "How are you doing?" He said, "Doing good. You just got me fired." I said, "Really?" I honestly couldn't remember writing the report. But yeah.
So I'm gonna slow you down and kind of interject with questions. So you had had previous contact with him before?
Yes, I had previous contact the night before this all happened. He had come in, he had been obviously upset about a situation about a female.
When you say the night
I'm gonna
before,
object, that's cause for speculation. He doesn't know whether my client is upset.
Okay. Did you want to respond to the objection at all?
Your Honor, I was going to have him explain how he knew he was upset, or the visible signs that he was seeing. But
Okay, I'm gonna sustain the objection, but you can continue your question.
Before that, I was going to, when you say the night before, do you remember what day you were referencing when you say the night before?
I don't remember the day specifically. I remember that it was the night before the event that led to him being terminated, his contract being terminated with the company, was the night before, where he had come in the building with a firearm.
Did you talk to the police about this at any time?
I talked to them the next day. Did not talk to them.
And would seeing a copy of the date on the police report refresh your recollection? Your Honor, may I approach?
You may.
Yes, I would object, Your Honor. I think the police report is hearsay and it was not written by my client, it was written by the officer. So he doesn't know what the officer put in that report, whether it's accurate or not.
Your Honor, his statement is contained within the report where he gives the officer a date of when this occurred, Your Honor. I was refresh his recollection as to that date, Your Honor.
Objection is overruled.
Right here. Just read it, please. Scan it real quick and look up at me when you're done. Did seeing that refresh your recollection? Okay, so what date? Do you now remember what date that was?
So 30th was the date that he came in, talking about how I got him fired. The 29th. The 30th was the day that he came in, talking to me about how I got him fired, and the 29th
That was hearsay what he said to him when we talked to him. I would object to any question.
Where's he talking about what the defendant said?
He was at that time, Your Honor. I was not gonna allude to anything the defendant said. I was gonna rephrase. I just asked about the date at this time.
Okay, the objection sustained.
So the date of the 30th, did you see Mr. Evans come in?
Yeah.
What did Mr. Evans do when he came in on the 30th?
He started talking to me about how I was the one who got.
I'm gonna object, Your Honor. That's seriously.
Okay, without saying what he said.
We started a conversation and he waited for his guests to come and get him.
And on the 30th, what was his mood? What was his visible mood like? Could you tell what kind of a mood he was in by looking at him?
He was upset.
And how did you know he was upset?
It's not something you can really put to a visual. You can hear it in his tone of voice. You can hear it in how he says his words.
Was he aggressive?
Yeah. I would say he wasn't aggressive, more passive aggressive, with his handcuffs in his pocket and he was playing with them. That specifically.
And on the 30th, you said he had handcuffs in his pockets? Yeah. And does Mr. Evans live there?
No.
And so when he came in, you and him had a discussion and he was visibly upset. He had some handcuffs, he was playing with them. Did he do anything else? On the 31st, did you have contact with him on the 31st?
That is the day after the police were called.
So the 29th, something happened with him on the 29th?
Yes, the 29th was the time that he said that was essentially what got me.
Can you speak up, please?
That-
Because you're actually speaking for me, not for him.
Okay, so the 29th is essentially that what happened on the 29th is what got him fired and what I think made him come in there and act aggressive.
Okay, so there was an incident on the 29th
Yes. That got him
that
fired.
caused the termination. Okay.
Yes.
Okay, so we'll go back to the 29th then. About what time did he come in?
It couldn't have been an hour and 30 minutes before my shift changed. So he came in, I opened the door for him. He asked, said hi, and he just ran through. That's how I knew of course something was wrong. He ran through the doors. Well, I followed him out there. He was on the phone with somebody. I heard the phone call. I heard what it was about. I don't know if that's hearsay for me to say it.
Did he confront you at this time?
No, he did not confront me. I confronted him, actually asked him what was wrong. I was more concerned with the situation at hand than him actually having a fire.
And so what happened after you confronted him?
What happened was he got on the phone. I listened to the situation. I tried to go through everything in my head, and then he left.
And did he come back?
He did come back one time. He came back through, and then I don't exactly know what happened after that.
And this was on the 29th. And then
He left and came back 2 times. So he went out once, came back, left again.
And did anything happen on any of those times that he came back?
He was just upset about the situation, obviously. From what I heard, it was obviously applicable to be upset at that situation.
What made you think he was upset?
How he was talking, how he was acting, the situation at hand, what I heard.
He was talking to you?
Yes, we did have a conversation about the situation at one point.
Okay. I know there's been an objection to hearsay, but a party's opponent's statement is not hearsay, it's admissible.
If they're gonna talk about an admission, I think they have to show the court was selected.
Correct, but there was an objection to him saying what he said. And it's a statement offered about the party opponent's own statement.
I would just have a standing objection. I think that applies to law enforcement.
She couldn't hear you. Can you repeat that?
I would just have a standing objection to that. I think that party opponent applies to law enforcement, but Your Honor will make the determination.
Okay.
So that all happened on the 29th. And on the 30th, you said, did he have the handcuffs on the 29th or the 30th?
He had them both days. He had it firearm and pistols on him on the 20 or handcuffs on him on the 29th.
And I'm gonna stop you right there. So how do you know that he had handcuffs
He showed
on you? He showed you? And how do you know that he had a firearm on
He
him?
showed me that.
And can you explain how he showed you?
I asked him what was going on. He said that he stated that he was going to deal with somebody. He said, I'm going to deal with somebody. Somebody is beating up on this woman that he was talking to at the time. He was having relations. And so that's how that's very applicable to be upset at it.
And then, so after he said told you that somebody was beating up on his woman, he was going to deal with it.
Right.
He then showed you that he had a firearm?
Yeah.
And how did he, one more time, how did he show you? Can you describe it?
It was in a side holster that was up underneath his right arm or left arm.
Did he have a jacket on at the time?
Yeah.
And did he lift that jacket to show you?
Yeah.
Your Honor, let the record reflect that the witness is pulling his shirt open, pulling his jacket open and pointing to right underneath the arm.
Okay. That's how we noted. You said, I'm just trying to clarify, you said that he said that there was someone who was beating on a woman or his woman?
I
woman.
don't know whether he was having current relations with them.
Okay.
Obviously he was.
You just said a woman.
A woman.
Got it.
And then he opened his coat and showed you a firearm. And what did that firearm look like?
To be fair, my recollection of it isn't the greatest. It was in a holster and it had a gray or tan foregrip with a black back to it.
And you said it was in a holster?
Yes.
Have you had any prior contact with firearms?
Very little.
Do you know what a pistol looks like?
Yeah.
So you're basing that off of your knowledge of what a firearm would look like? And did he do anything else after that?
No.
And then he came back the next day?
Yeah.
And the next day, did he have that firearm with him the next day?
Not that I know.
No further questions. Time now. Thank you.
Cross-examination.
You said you worked security for that complex. Did you work actually for the complex or did you work for a security company?
I worked for Edmonds.
Okay, and you had several other complexes that you also worked for.
Yes.
And you said you were familiar with my client. You didn't work with them, but you were familiar with him and that you two would change shifts. Are you still employed by that security company?
No,
And when did you leave the employment of that security company?
I left the same night because I felt like I was pushed into having to this situation. Essentially, I didn't want any of this to happen with me. I didn't want to write the report in the first place. So I was pushed into this situation because I was the one who's seen all of it happen, not how I wanted it to go down the hall.
Did you voluntarily leave?
Yeah. Yes, I did.
That was based on the fact of you didn't want to be pushed into this situation.
Yeah.
What does it mean
No.
pushed into the situation?
They
I
were
don't get
telling me that if I stayed in that dangerous situation, if I stayed on site there, or if I left the site, that I would be terminated from the contract. So I left that
Got
night.
it. Okay.
You say you had you never worked with my client one-on-one person. So how did the security shifts work there? How long did you work?
I worked 3 to 11, and at 11, and partner Colin.
So you had partners that worked with you or you were alone while you worked?
We had partners. I have a site supervisor that worked with me who should be here instead.
Were you ever aware of who Mr. Evans' partner was? Who was that?
That was Colin. I'm not exactly sure of his first name, but I know.
Okay. Now, there's been 3 dates that have been mentioned in court today, the 31st, the 30th, and the 29th.
Right.
Did you have contact with police on the 29th?
No, I did not have contact with the police on the 29th. I was pushed to sign the report on the 29th, which led to the police being called the next day.
Okay, so you had contact with police on the 30th.
Yes.
Did you give them a copy of your report?
No, I did not.
Does your company, to your knowledge, keep records and copies of those reports.
Yes, my knowledge they do.
And you signed this report.
I can barely even recollect signing the report, but yes, I did. I looked at it and it said my name at the bottom, so yes.
And that report would be an accurate reflection of what happened on the 29th from your perspective.
Yes.
You ever had any problems with my client before on your work job? Now, it is true that my client did have friends and family living in that building. Were you aware of that?
I was aware of his cousin up on the second floor. but
Cousin on the second floor, and that would be family.
Yes.
Now, you said when he came in at some point, and I was confused as to what date, you said that someone came down to get him one time.
Oh, yes,
Maybe I
the
was-
guest came down.
So this was a guest.
Or not a guest, the tenant of the unit came down to get him. I don't know what his relation with him was, but I know he went up.
You know what unit that was that this person came down from? Was that a male or a female? Was this on the 29th or the 30th?
This was on the third.
So the day after.
Yes.
Now, you indicated the weapon you saw had a tan grip.
If I can think about it correctly, yes. I don't know whether that could be completely true or not. My recollection of my memory of the situation is so it was in a holster. I know it was in a holster and I can see that it was a pistol.
And this did happen approximately two weeks ago, 2.5 weeks ago. And at this point, you're having a hard time recalling exactly what the weapon looked like. Now, to your knowledge, do they have security cameras at the complex? Did you ever review any of the security tape from the complex for your report?
Yes, we did. Actually, Tanisha was the one who did that. Tanisha Atkins, my site supervisor, was the one who did that. I think I should be.
And she reviewed the security tape.
She was the one.
You know, from your knowledge, was the security tape ever provided to the police?
From my knowledge, no, but it could have very well.
Okay. But you did review that, so there is security footage available.
Yes.
And how many security cameras do you have in the lobby?
In the lobby, there's one up above the door, right here. If you think about it, when you walk in, there's a wall right here. There's one right there, and there's one out in the external lobby coming into the building. And then aside from that, there is one up the top, right outside of the security office, which is where our stain how it's off. You can see all the way down the first hall.
So if we were to review that security camera in the lobby, it would show that movement that you described? Now, you said you talked to the police on the 30th. On the 29th, did you call the police at all when this weapon was?
Nope.
You said
No, I did not.
And why did you not call the police at that time?
Because that situation was not applicable to all the police. And he was obviously upset and irate about something that had nothing to do with that building. Had absolutely nothing to do with the situation that I was in. I have to keep the security of that building. Obviously, I'm going to add it to the report, but he wasn't making any dangerous threats towards the building or anybody in the building.
Okay. Have you spoken with the police since that time? Have you spoken with the prosecutor today about your testimony? And when was your last day of employment at that location?
The 30th.
Do you know if there's anyone who works security that lives in that building?
I do. My site supervisor, Tanisha Atkins, she works security. She was my partner on second shift.
So when you had contact police on the 30th, you discussed your report with them.
Yes,
Did you personally contact them or your company?
my
contacted
company did. I was not the one who contacted them. I called my supervisor, Kyle. And all I did was wonder how he got the information that he had. That's all I did. I wondered how he got the information as to how he figured out that I was the one who wrote the report. Because I was aware that I wrote the report. I gave the phone to Denise Atkins and she submitted the report. I didn't know.
Okay. You know if the police ever found my client with a gun from your personal knowledge?
No, I don't know.
No further questions.
I just want to make sure I'm clear. January 29th was the day of the incident. In which you saw this gun allegedly?
Yes.
Okay, and then you reported it to someone?
I reported it in my main report. We make reports every time we do, so anytime anything happens or anytime we do a round of the building, we make a report.
Okay,
So
that was on the
this
29th.
situation happened, so obviously I made a report of it, but
On the 29th?
Yes.
Okay, and then, but you don't recall the written report is what you're saying?
no, I don't recall signing it.
Signing
I
the
recall helping Tanisha Atkins make the report. And I recall helping her make the report and sitting in there and watching the footage,
Okay,
but I handed the phone back to Tanisha Atkins
gotcha, okay.
and she submitted the report. And apparently
I
my
have one follow-up question. So your supervisor helped you with that report?
Yes.
So she was present the whole time you wrote that report? And did she type out the report, write it out physically? How did that go?
She helped me. So we both physically typed that report
Now you're doing this. Did you do that on a phone?
on a phone. We have a Silver Track. It's called an app. It's an app, and on the phone it's called Silver Track. And you just put all your reports in. It leads all directly around.
Did she help you make any corrections to that report
Yes.
at her suggestion?
Yes.
So it'd be a fair statement to say she was not present on this night, but she helped you write that report and helped you make corrections to that report. But she had no personal knowledge of what happened that night.
She did. She was there the whole entire time with partners. So when this situation happened on the 29th, I was sitting out in the lobby. I opened the door for him. She obviously saw him come in and she stepped out as well. And I talked to her while he was on the phone talking to the lady.
Did she see the handgun?
She did not. She saw his handcuffs.
And one of the major purposes of that report was because of the handgun?
Yes.
But she didn't have any personal knowledge to the handgun,
No.
correct? And she helped you write that report concerning the handgun. And she helped you, and you made corrections at her suggestion.
Yes. Based on what we saw on the film.
Redirect.
Yes, I have something. All right. So on the 29th, you said he came in with a handgun and handcuffs?
Yeah.
And he was visibly upset?
Yeah.
And he said somebody was messing with his girl?
Yes. Or somebody was beating up on this.
And you didn't think that that was a security concern, somebody coming in with a handgun and handcuffs?
Well, I didn't think it was a security concern for the building overall. I think whatever happened between him and that other gentleman or other man, that's between them.
You did.
Obviously, I'm going to write it in the report because it needs to be documented. But
Why did you write that in the report if you weren't concerned about it?
Because I was told to by my site supervisor.
Quick question, the person, okay, so was your understanding that the person that he was coming to address lived in the building or was in that building?
I was aware that the woman lived in the building and that she had left and that the man was also not in the building. He was just there. I have no clue.
Okay.
And so you didn't call the police on that day? Is Adrian Evans in the courtroom today?
Yeah.
Can you point him out and describe something he's wearing?
With a black coat.
Let the record reflect that the witnesses identified the defendant.
Any objection to identification?
I don't have an objection this time.
Identification is noted.
I have no further questions. Time, Your Honor. Thank you.
Okay, may this witness be excused?
Yes, Your Honor.
Thank you, Mr. Royston. You may be excused. Any additional witnesses?
Nothing for people, Your Honor. People rest this time.
Defense calling any witnesses today? Any witnesses today?
I'm sorry, Your Honor. I was talking-
No worries. I just asked if you're calling any witnesses.
No,
today.
no witnesses on that.
Okay,
No, Your Honor.
thank you. You can proceed to argument.
Thank you, Your Honor. At this time, the people will be amending the complaint to reflect the 29th of January. Your Honor, the defendant is charged with carrying concealed weapons, pistol. You know, in order for the prosecution to prove that, we have to prove each of the elements. First element, he knowingly carried a pistol, and then second, that the pistol was concealed on his person. We heard testimony from Gavin Royston today that said that he saw the defendant walk up to him, had a pistol concealed under his jacket, had to move his jacket to show him a pistol. He described, based on his knowledge, that it was a pistol and it was concealed under his jacket, Your Honor. And he described the weapon. He described seeing it in a holster. He described seeing the handle and the butt of it, Your Honor. At this time, the people would ask that it be bound over on all counts in the complaint, Your Honor.
Thank you. Ms. Cartwright.
I don't think we've had any testimony today that my client does not have a concealed carry permit, Your Honor. That would be one failure of this charge today. This sounds like it's all based on circumstantial evidence. I understand circumstantial evidence can be the basis for a bind over. This may be a factual question for the jury at a later date. All I heard today is jacket was open, there was a holster. I don't even know that he was carrying it concealed. It's very open about what he had back then. So I'm going to ask you not to find this over any major flaw in this charge. There's no showing today that my client does not have a concealed carry permit.
Yeah, just briefly, one of the elements of the crime is not that he has a seatbelt. That's not an element that needs to be met, Your Honor.
Today's the date and time set for preliminary examination. Again, we have a felony complaint, 1 count of weapons carrying concealed. The time of the examination, the burden is squarely upon the prosecution to establish that there's sufficient probable cause that a crime was committed, insufficient probable cause to charge you with the crime. This is not a burden that should be compared to what their burden will be if this matter were to make it to a trial. Trial, they have to prove each element beyond a reasonable doubt. Much higher burden. This is just a burden of more than mere suspicion. It can be based on circumstantial evidence, or it could be based on direct evidence, but it's based on information provided to the court today at the time of the examination. We've had testimony from one witness today, that being Gavin Royston. He testified that he worked at the address of 3200 South Washington, City of Lansing, Ingham County, State of Michigan, making venue before this court appropriate, that he was a security officer, and that there was an incident that occurred on the date of January 29th, 2023, in which he identified the person as Adrian Evans, who's seated as the defendant, appeared to that address, and then he opened the doors for him, and that the defendant appeared to be upset about something relative to someone beating a woman, and that the defendant brandished or showed his firearm by opening his jacket, that he could see that there was a pistol in a holster. He wasn't 100% sure about the color, whether it was gray or tan, of the handle of the holster. And then he later made some report, it sounds like 2 days later, maybe the law enforcement was called. Criminal jury in Michigan, criminal jury instruction 11.1, carrying concealed weapon pistol requires that at the time of a trial, the prosecution would need to prove 2 elements. One is first that the defendant knowingly carried a pistol It does not matter why the defendant was carrying the pistol, but to be guilty of this crime, the defendant must have known that he was carrying a pistol. Second, that the pistol was concealed on or about the defendant. Complete invisibility is not required. The pistol is concealed if it cannot easily be seen by those who come into ordinary contact with the defendant. Mr. Cartwright makes the argument first that there was no information or evidence provided today to determine whether or not Mr. Evans had a concealed weapons permit. That's a question that even struck me as we was going through this. Fortunately, it's not an element of today, but could be a defense to the underlying charge, and that defense could be made at the appropriate time, but it doesn't require, or it's not an element required to be met today for the purposes of probable cause. And then the other argument was that the firearm was as alleged to be carried by the as alleged by the witness was in plain view. It was open, it was visible, that he was clearly showing it. But the testimony was that he had to open his jacket to show the firearm, which would cause the court to believe that that weapon, if carried, was concealed. And so the court is satisfied that there's sufficient probable cause for the purposes of today's hearing to bind this matter over to the circuit court for further proceeding. And for any potential defenses or questions of that to be properly addressed at the circuit court level. So this matter will be bound over to the circuit court. The bind over date is March 1st. Do not need to appear in court on March 1st. Okay, sir? That's the date that they'll get the file from this court. They'll set it for a pretrial. Then Mr. Cartwright will be made aware of that date, okay? Definitely on the record right now. Okay, bond was set at 2,010%. That will continue. Any additional matters at this time?
All right, we have one motion concerning bond amendment. Based on what we heard earlier today, and the fact that the alleged victim in this case no longer is employed and is not at that location, I think the no contact order indicates he did not have contact with the security guard who's not working there anymore. I don't think it applies to Washington, 200 South Washington. He does have friends and family in the building. We just want to make sure that that's on the record. That no contact order is entered. I think only applying to the victim in this case is no longer at.
Wouldn't even, well, I'm not sure who a victim in this case is. A security concealed weapon. So there's no victim named here. The carrying concealed isn't a charge that has or contains a victim. Nonetheless, the PA-53 clearly says do not assault, harass, intimidate, beat, molest, wound, threaten 3200 South Washington. So I will remove that from the PA-53 because I don't understand it.
And just further, Your Honor, my client's fiance who lives with her, she lives in the building. Correct. So that's okay.
Oh, okay. That's no problem. It never named a victim. I'm not sure who were even. I'm assuming you're talking about Mr. Royston was the victim. I don't know who the
Yes, I was
victim
talking
was.
about Mr. Royston.
Okay, yeah, I don't think he could be a victim in this particular matter, and it doesn't say or list him as a victim. It lists the building as a victim. So that element will be removed from his bond condition. Any additional matters?
Nothing about people. Thank you, Your Honor.
Bond otherwise will be continued. Let's see. No problem, we're all set on that. We're running the last one with Austin.
We are, Your Honor.
My apologies, Your Honor. I thought you were.
No, we were still on the record. You knew that. Need a prosecutor and we're good to go. It's supposed to happen tomorrow too. Yeah,
I can't remember what's going on.
I don't need
We
that.
have like things we're supposed to be watching, presentation.
This is interesting. Hey, we're on the record in the matter of the people of the state of Michigan versus Miguel Angel Castanon, file number 23-00327 FY, council appearance.
Brian Ring on behalf of the requesting intermission court rule 8.120.
Good morning, Your Honor. Jared Alphen, bring on behalf of Mr. Castanon. He is present with me today at council table.
Okay, Mr. Castanon, we are finally ready to proceed with your matter today. Thank you for sitting patiently.
Of course.
Okay, and do we have any preliminary matters before we begin?
None from the people, Your Honor. I asked you.
Your Honor, since there's going to be two witnesses, I would ask for an order of sequestration.
Okay, sequestration order will be granted. Where are your witnesses?
They're currently in conference room 2, Your Honor.
Okay, sounds good. You can call your first witness.
The people call Allison Tripp.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Can you have a seat here, ma'am? There's a microphone that's in front of you. The lady that's sitting behind you is my court reporter. She has to take down everything being stated here today. So all of your responses must be verbal. You cannot do head nods or shakes or movements and ahas because she can't write that into the record accurately, okay? You want to keep your voice up loud and clear, especially since we have fans running, so it drowns out the noise a little bit. And this right here, it makes it hard for me to hear you. You're actually speaking, you're answering their questions, but it's for me to hear, okay? So I have to be able to hear you. If you don't understand a question, you can say that you don't understand, or you can ask to have anything repeated if you didn't hear. And then lastly, if there's an objection from either of the attorneys, you would stop any answer that you're giving. I'll give a response and I'll advise you whether or not you can give that answer or not, okay?
Okay.
State your first and last name and spell them both.
Allison Tripp, ALLISON TRIPP.
Oh, you can proceed, counsel.
Thank you, Your Honor. Mr. How are you today?
Thank you.
Mr. Do you know Colette Foster?
I do.
How do you know Colette Foster?
I've been one of her best friends since early middle school.
You speak with each other regularly?
Yes, we live together.
Oh, you live together. Back on the 29th of January, were you with Ms. Foster?
Yes, I was.
Was there anybody else with you at that time?
Yes, the defendant, Miguel
Miguel,
Angel,
you know Miguel's last name?
Castanon.
Is that person that was with you in this courtroom today?
Yes,
And can you point to him and describe something he's wearing?
he's sitting right there on the right.
Will the record reflect that the witness has identified the defendant?
Any objection?
Without objection.
Identifications noted.
And what were you doing on that day?
We were at our house with Colette, Miguel, one of his friends, celebrating his birthday.
Whose birthday?
Miguel.
And did you go anywhere that night?
I did not know.
What happened when you were celebrating his birthday? What happened during that time?
Colette, Miguel, and his friend had just come home from a bar, I believe. She said that they had been arguing a little bit earlier in the night because he was jealous. He thought his friend was flirting with her. So things were a little tense.
Did you see them arguing?
Yeah, yes, they were arguing in the kitchen.
Go ahead.
And then we just hung out. We played Uno. We had a couple drinks.
Did Colette leave at any point?
She did. Later in the night, she left.
Did she leave by herself?
She left with Miguel.
What was her demeanor when she left?
She was upset. They had just gotten into a fight. He had gotten very loud and aggressive in our home, and I asked him to leave. He left.
When you say you got aggressive in your home, can you describe how he was being aggressive?
Nose to nose in my face, arguing with me.
Was he yelling? Was his voice
His
raised?
voice was loud. He wasn't yelling, but he was loud.
And so when they left, did anybody else go with them? Was it
No,
just Miguel?
just them two.
Did she return to your house at any point?
She returned to my house probably 20, 25 minutes later.
Was she alone?
Yes, she was alone.
What did you notice when she returned?
I noticed her face was bleeding and red. She had red scratch marks on her neck. She was sobbing, hysterical, very upset.
Did she describe to you what happened?
Yes, she did describe to me what happened.
And did you call the police or did she call the police?
I called the police. Her nose ring was missing.
No further questions.
Prosecution.
Sure, thank you. Good morning.
Morning.
So you had mentioned there were you, Miguel, Colette, and you said another person. Is that correct? You know who that other person was?
One of Miguel's friends. I can't recall his name, to be honest.
Is it someone you were?
The first time I met him.
And this was a celebration, is that correct?
Yes.
You indicated that there was drinking, is that correct?
Yes.
Had you been drinking anything that night?
I had a couple of drinks after they got back.
And what had you had to drink and when?
I had maybe 3 shots of tequila. Put up more time.
Over what period of time did you have those 3 shots?
I can't remember exactly what time, probably like probably 1, yeah.
And did you witness Colette drinking anything that night?
I think she probably had 2 or 3 shots. I think.
Same thing you were consuming?
Yeah.
And you consider yourself friends with Colette, is that correct?
Yes.
Okay. And have you had occasion to speak to her about this incident since it has occurred prior to today?
Yes.
How many times?
We live together, so I see her all the time.
Did the 2 of you come to court together today?
Yes, we did.
Did either of you discuss what either of you were going to be testifying to the court today?
We discussed the events that happened, like why we're here today, but we didn't discuss our testimonies. No.
So either you or Colette did not go through some type of practice run as to what you're
No,
going to
we
say
did
or
not.
not say? Have you reviewed any police reports or any statements prior to testifying here today?
No, I have not.
Brief moment if I may, Your Honor.
No problem.
Thank you. I have no further questions.
I just really quickly, Ms. Tripp, this incident took place at your home?
Yes, at my home,
What's your address?
904 North Walnut Street.
Is that in Lansing?
Yes, Lansing, Michigan, area code 48906.
I think Judge just covered one of my questions there, and I only have one other question. Have you spoke with me about this case at all?
No.
Thank you.
May this witness be excused?
Yes, Your Honor.
Okay, Ms. Tripp, there's a sequestration order, so that means you cannot discuss any portions of your testimony with any other witnesses, okay? Thank you. You may be excused. Please call your next witness.
People call Colette Foster.
Sequestration order. She must be-
Your Honor, may I approach to have two exhibits marked while we're in this?
Yeah, you may.
Downtime? Thank you.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Yes. Thank you. You can have a seat there, ma'am. Okay, so there's a court reporter. She's right behind you, and she's here to take down everything that's being stated. There's a microphone in front of you, so all of your responses, ma'am, they must be loud and clear. They must also be verbal so we can hear you, okay? You cannot answer any yes or no questions with a head nod or shake or mm-hms or uh-huhs because we can't write that into the record. If you don't understand the question or if you need something repeated, you can say so. And then if you need a break for any reason, you can also request a break. Do you understand that? Yes. And lastly, if there's an objection made by any of the attorneys, you would stop your response. I'll make a ruling on that objection, then I'll tell you if you can give that response or not, okay? Please state your first and last name and spell them both. Proceed, counsel.
Thank you, Your Honor. Go ahead. Where do you live? Is that in Ingham County?
Yes.
Who do you live there with? And how do you know her? Back on the 29th of January. What do you remember what we were doing on the 29th of January? Can you speak up a little bit, please? The judge is having a hard time hearing with the fans on. Judge, may I turn the fan off?
Yes,
for
please.
this? Thank you. Sorry, say you were there.
My boyfriend, yeah.
What's your boyfriend's name? You have anybody else?
At first, we were at this, it was house the other day, and we were at the house.
We can hear nothing she's saying.
Speak a little bit more. I understand this is hard.
We were at his house around his family in the day. And then we ended up at my house later on that night.
And who was with you? Who was with you at your house that night?
My roommate, Allison, Chip, and his friend.
Fine. What were you doing at your house?
We were just hanging out, drinking and playing card games.
Did you get into an argument with Miguel?
I wouldn't say that I got into an argument because I wasn't arguing. It was more of a one-sided argument with him yelling at me, saying, it's just laying on the couch.
So you were laying on the couch and he began to yell at you?
At first, he got angry, tried to go to bed, and I didn't want him to jump drive his friend home. And so they left, and I just like went and lay back down. I just wanted to go to bed. And then he came back looking for his phone, and that's when he started standing over me, yelling at me, and my roommate.
What was he yelling at you about?
That I'm stupid, that this is like why we're breaking up, because I'm letting my friend kind of tell him to take me upstairs and go to bed. And
Has he yelled at you like that before?
yes,
How close was he to you when he began yelling at you?
like a good, like maybe like a foot.
And after he began yelling at you, what did you guys do next?
My roommate told him that he needed to get out of the house. He tried to get in her face and she wasn't backing down. She was kind of like guiding him towards the door to get out. I stood up because I was afraid of what would happen between them. So I stood up, I got in between them, and we got out to the porch, and they were just yelling at each other. I don't know. It was threatening. Just threatening him.
Did you eventually leave with him?
Yes.
Do you remember why you left with him?
He called me. He told me that he just wants to go home and lay down, and told me to come with him. And that's all I wanted. So I thought that it would be okay and everything would blow over.
Were you in your car or his car?
His car.
And were you driving or were you the passenger?
I was in the passenger seat.
And about how far is it from where you guys were at his house?
10 minutes.
And you got in as you get away. What do you remember happening on that drive back to his house?
First, he was telling me that I need to.
I'm sorry?
He was telling me that I need to move out of my house. He doesn't trust me there if he's not gonna be there. 'Cause my roommate said that he wasn't around there anymore, and I just was like, I don't have anywhere else to go. I really thought it would all blow over and that we would all to move on from it. And yeah, then he just was telling me stupid bitch, and you just saw that. And then he started to say that he was gonna kill me, he was gonna drug me, he was gonna shoot me. I wasn't really taking it seriously at that point. I was just like, okay.
Has he ever made those threats to you in the past?
Yes.
So you're in the car with them. It's only you two in the car? Is that it? Sorry.
Yes.
Was it only you two in the car? That's my fault. I didn't answer the question.
Yes.
Were the doors locked?
I can't remember. I think I remember like when I was trying to get out, unlocking the door. But
And so while he's making these threats to you, what happened after that?
he told me to get out of the car. He didn't stop or anything. He just was like, I'm gonna drop you off on the side of the road. It was freezing, and I just wanted to get back to my car. I was at his house, so I was like, I'm not getting out of the car. And then it was kind of changed, and
Can you try to describe how his tone changed?
just like not even human. Like it was very aggressive, and I was fucking terrified at that point. So he was telling me to give in my phone. I was afraid that he was going to do something to it.
Why? Do you know why he wanted your phone?
I believe he was looking for photo or video evidence of him threatening us earlier, is what I gathered, but I don't really know. And so when his voice changed and he was demanding my phone, I told him to let me out of the car, and he didn't. He started grabbing at me, grabbing at my pockets to see where my phone was. He started to grab up my neck, try to pull me over to the middle console and hold me down.
How did he try to hold you down?
His hands like
Where-
on my neck.
So he placed his hands on your neck.
Yeah, and then I kept flailing and I tried to get away. I tried to,
Was it one hand on your neck or both?
at some points it was one and at some points it was both, because he was trying to steer the car. And I was trying to steer it into like something so that I could get away. But then I got scared and I got away from the middle and I got the door open and I was kicking it open and he was pulling me back by my hair. The whole time I was begging him to please stop.
Did you ever feel like you couldn't breathe?
Yeah, so after I had kicked the door open, I was trying to get out, but I couldn't. He was holding me by my hair. I was screaming for help, thinking maybe someone would hear me. And he grabbed me back. He grabbed me over my mouth. He grabbed me back to the middle.
What? I'm gonna slow you down for a second. Okay? You said he grabbed you by the mouth. How did you describe how he did that? The record reflects that the witness is showing him placing one hand over her mouth, covering her mouth, and pulling her head back.
So, and then
He was pulling you by your hair.
yeah, and then when he pulled me down my mouth, grabbed me back to the middle, he was like grabbing, like almost pinching my like my jugular. That's when I kind of felt like I couldn't really breathe. I was
How many times did you try to get out of the vehicle?
like the whole like that whole time until he had me by my hair and he started hitting my head against the radio saying, "Give me the fucking phone." And so I found out where my phone was and I tossed it to him so that maybe he would stop putting his hands on me. He was yelling at me for the password and I gave it to him and he was driving, doing something on my phone and I was just sitting there like crying. I was so fucking shocked and afraid and he asked me why I was crying, told me to shut the fuck up.
Did you eventually get away?
Yeah, we got back to his house. He tossed my phone at me, he said something to me I don't remember, and I bolted out of the car and got into my car.
Where did you go after that?
I went straight home.
Did you tell anybody about what happened?
Yes, my roommate had texted me, saying to contact her in the morning, let her know I was okay. I told her that he just beat me up, and she immediately FaceTimed me and stayed on the phone until I got home. And
Were any pictures taken of your injuries?
I took pictures on my way home. I didn't feel real.
May I approach your honor? Showing the witness has been by people's proposed 1 and 2. Can you take a look at those for a second? Just let me know when you're done. Are those the pictures that you took? And people's proposed 1 and 2 of those, they're inaccurate representations of your injuries you sustained. Your Honor, at this time, I would move to admit people's proposed 1 and 2 and publish them to the court.
The objection.
Without objection.
One to a minute.
That's what you're.
You may.
And wait for them to go. Is he here today? Can you please point to him, describe something he's wearing?
Yeah, sure.
The record reflected with witnesses identified the defendant.
Identification objection.
Without objection.
So noted.
Question. Time, Your Honor. Thank you.
Cross exam.
Sure, thank you. So am I understanding your testimony correctly? The 4 of you were drinking and playing cards that night, is that correct?
Yes.
Were you drinking as well?
I wasn't drinking much because I had a stomach ache. So the whole night in total, I had 3 shots
3 shots of what?
of tequila. The last one was about an hour and a half before the incident.
And you were additionally describing an argument where you were describing Miguel in the house as being angry and calling your names and so forth. Do you recall that?
Yes.
And you did not want him to drive his friend home because you were concerned that he may not be able to safely do that. Is that correct?
Yeah.
And how long after that was it when you got into the car with Miguel?
Maybe like 10, 15.
10 or 15 minutes?
Trust me, it's my biggest regret. It's getting in that car.
And it stated on your direct testimony that the threats that Miguel was saying to you in the car, you were not taking those seriously at that time. Is that correct?
Yeah.
And you were describing him grabbing you sometimes with one hand and sometimes with two hands. And was that while the car was running and in motion?
Yes.
He was driving the car at the time that he was doing this?
Yes.
So there was, at some points while he was driving, that he had both hands off of the steering wheel and onto your body or attempting to on your body?
Yes.
Did he ever swerve off a road or strike anything with his car while this was occurring? And where this was occurring, was this residential neighborhood or somewhere else?
Yeah, it was a residential street.
Eventually you got to a destination and you got out of that car, is that correct? When that happened, he did not try to prevent you from leaving the car when you got to where you were going and exiting the car, is that correct?
Sorry?
So he had already done what he wanted to do, so it was really over at that point.
And you were testifying and demonstrating to the court a little earlier that Miguel had one hand over your mouth at some point. Is that correct? Did you tell that to the police that night when you talked?
I don't believe so. I told them that I was trying to scream for help and that he was stopping me, but they didn't really ask.
And you did not tell them that particular detail. Is that correct?
I don't think so.
And you stated you live with Allison Shrimp. Is that correct?
Yes.
And two of you are very good friends. Is that correct? Did you come to court together today?
Yes.
Did either of you speak about what you were going to be testifying to in court today?
Mm.
Have you discussed your testimony with Allison prior to today?
Mm.
Have a moment, Your Honor.
No problem.
Your Honor, it's all the questions I asked.
Thank you. Redirect.
Foster. Hand over your mouth. And you were trying to help with them. Remember if the car door was open or closed. Finish. Hand over your mouth. Was doing anything else at the time or saying anything else?
It was very quick. It was also quick. Well, me making back.
May this witness be excused?
Yes, Your Honor.
Okay, I need to advise you that there is a sequestration order, so that means you're not allowed to discuss any portions of your testimony with any other potential witnesses in this case, okay? All right, thank you. You may be excused. Any other witnesses?
No, not this time, Your Honor. Thank you.
The defense be calling witnesses today.
We'll be relying on the evidence presented, Your Honor.
Please proceed to argument.
Your Honor, this time the people would like to add account 3 of unlawful imprisonment under MCL 750349B. And that would be 1B, secretly confine or knowingly restrain, or 1C, knowingly restrain or facilitate the commission of assault by strangulation, a felony. Or 1D, did knowingly restrain a victim to facilitate flight after the commission of assault by strangulation, felony.
We can proceed with your argument.
Thank you, Your Honor. Your Honor, we had 2 witnesses today, Your Honor. Ms. Tripp came in and testified that she saw the defendant becoming aggressive with the victim before this happened. He became aggressive with her as well, and then she decided to kick him out. We heard from the victim who decided to leave with him. Maybe it'd be best if she left with him, but this would all blow over, Your Honor. Your Honor, she was terrified. She left with him. And during that car trip, Your Honor, the unthinkable happened to her. She testified how he grabbed her by the throat and began to strangle her, Your Honor. She testified how he tried to take her phone away multiple times. She testified that he took her by the hair and smashed her face onto the radio, Your Honor. She testified that she had trouble breathing and she lost her breath at points. Your Honor, she testified that she tried to leave multiple times during this incident and he would not let her leave, either by pulling her back into the vehicle or just continuing to drive, Your Honor. At one point, he even put his hand over her mouth to stop her from getting out and yelling at anybody, Your Honor. Your Honor, at this time, I would ask this be bound over to circuit court on all counts and the added count of unlawful imprisonment.
Thank you, Your Honor. Understanding the burden of proof is probable cause at this stage, which is a low standard, I'm aware, but it is a burden they must. Court is the sole determiner of credibility at this stage. Certainly, Miss Tripp was not privy to anything that may or may not have happened between Mr. Castanon and Miss Foster that may have occurred at the vehicle. So we did hear testimony from Miss Foster. Her testimony was that Mr. Castanon was assaulting or attempting to assault her while the car was in motion, while he was driving the car, at some points taking both of his hands off the steering wheel in an attempt to strangle, sometimes with one hand, sometimes with both hands, while the car was supposedly in motion going down a residential. The court is the sole determiner of credibility at this stage, and I would ask the court to consider that testimony when making that determination, I would submit to the court that that is not credible evidence. I don't believe further, Your Honor, that there is sufficient evidence to justify adding a charge of unlawful imprisonment. Because essentially what they are asking the court to bind over on is that Mr. Castanon supposedly was attempting to prevent Ms. Foster from escaping or leaving the vehicle while it was in motion, either during or after the supposed assault had occurred. But even she admits continued to drive. It got to the destination and she left the car without any incident. He wasn't trying to keep her in there. He wasn't trying to confine her or stop her in any way. So I would certainly ask that the court not bind over on what the people requested to be an added charge. And I would ask for the remainder of the counts to be dismissed for lack of probable cause.
Mr. Ring.
Your Honor, Ms. Tripp might have not been there. She saw the aftermath of it. She testified to the injuries that she saw, which are exactly what the victim had told us happened, Your Honor. Furthermore, she did eventually get away, but that was after he got what he wanted. That was after he assaulted her. That was after he stopped her from getting while he was assaulting her. And that was after he got her cell phone that she gave him because that's what he wanted as well, Your Honor. So this all happened in the span of this car while she could not get away. She was confined in this car and could not get away. He was not going to let her get away, Your Honor. Thank you.
It was the date set for preliminary examination. At the time of preliminary examination, the burden is squarely upon the prosecution. They must put forth sufficient evidence to establish that there's probable cause that a crime was committed and probable cause to charge you, Mr. Castanon, with the crime. This is a burden that is just more than mere suspicion. It's not a burden that should be compared to the burden that they would have to face if this matter were to go to trial. At trial, the burden is on them to prove each other beyond a reasonable doubt. But this is a relatively low burden as indicated by your counsel during his argument. And the court is the sole determiner of credibility. And I have to measure the evidence and whether or not it raises reasonable doubt. And so today we had testimony first from Allison Tripp, who indicated that on the date of January 29th, at the address of 904 North Walnut, City of Lansing, County, State of Michigan, that all the parties, that including an alleged victim of Colette Foster, who was her roommate at that address, and the defendant that she identified as Mr. Miguel Angel Castanon, were present there celebrating, I think it was the defendant's birthday, and then an argument or dispute ensued, and that the defendant, according to Ms. Tripp, became aggressive and loud, that there was some nose-to-nose yelling, and that both the defendant and the alleged victim's Foster eventually left. Ms. Tripp later, or testified that later the victim returns to the property or the address of 904 North Walnut, and that her face was bleeding and there was redness when she returned, and that they called the police. We heard testimony from Colette Foster, the alleged victim in this matter. She identified the defendant as her boyfriend, and she said that they were late. She was laying on the couch when the initial argument at the address of 904 took place, and that after the argument or the engagement between her boyfriend and her roommate, that she agreed to leave the property to go with the defendant, thinking that the issue would blow over, that as they were in the vehicle, he was arguing, the defendant began to argue with her, or yell at her about moving out or getting a new roommate. That he demanded her phone, called her a stupid and said that he would kill her. She said she didn't take that necessarily seriously, and that he had made those threats to her on prior occasions. She testified that there was a point in which the defendant's voice changed, and she described it as being not human, and that he demanded her phone. She said, to be let out of the car at that time. The defendant refused to let her out of the car. She said the defendant grabbed her by the neck, pulled her to the middle console, and held her down with his hands around her neck. And she said at some point it was one hand, some point it was both hands, because he was steering the vehicle during this incident. She also described being grabbed by the mouth by one hand, her head being hit up against the side console, and also her hair being pulled. That she eventually gave the defendant the phone. She also described that the defendant put his hand over her mouth as she was attempting to call for help, and he eventually stopped. She pushed the door open and was able to get out of the vehicle. The people have admitted exhibits 1 and 2, which were pictures that show red marks around the alleged victim's neck. Assault with intent to do great bodily harm less than murder or by strangulation is count 1. And to prove that at trial, the prosecution would need to prove first that the defendant tried to physically injure another person. Second, that at the time of the assault, the defendant had the ability to cause an injury, or at least believe that he had the ability. Third, at the time of trial, the prosecution would need to prove that the defendant intended to cause great bodily harm. Actual injury is not necessary, but if there was injury, that may be considered as evidence in deciding whether the defendant intended to cause great bodily harm. Great bodily harm means any physical injury that could seriously harm the health or function of the body. This is charged as assault with intent to do great bodily harm less than murder or by strangulation. The testimony today from this Colette Foster, was that the defendant grabbed her around the neck once or sometimes with one hand, some with the other, and that she had difficulty breathing, and that he was trying to pull her to the center console while holding her around the neck. Mr. Austin makes the argument that the witness's credibility should be in question because the testimony is that this took place while the defendant was operating a motor vehicle through a residential neighborhood. When I heard that testimony, that's my biggest concern was that about him operating a motor vehicle. As to the credibility of the witness, she presented herself today to be distraught, to be overly emotional throughout even before she took the stand, and during portions of her testimony, extremely tearful. There's nothing that indicates to the court that any portions of her testimony should be considered uncredible. The testimony as to the strangulation during the operating motor vehicle, it could have happened. I know I could steer a vehicle with my knee if necessary, if I'm trying to open a bottle of water. Or she made testimony that the individual identified as the defendant had left to take someone to drive someone home under the influence. Maybe there was some reckless driving taking place there. I don't know. I don't believe that her testimony lacks credibility. So with that regard, count 1 as charged will be bound over to the circuit court. I believe there's sufficient probable cause. People are asking to add a count 3. Count 2 is domestic violence, and so that will accompany count 1. People are asking to add a count 3 of unlawful imprisonment. Michigan Jury Instruction 19.8 of unlawful imprisonment requires the prosecution to prove at the time of trial. First, the defendant knowingly restrained another person. Restrain means to forcibly restrict a person's movements or to forcibly confine the person so as to interfere with the person's liberty without that person's consent or without lawful authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. Second, the people would need to prove the defendant did so under one or more of the following circumstances. I think Mr. Ring requested that it be under either B or C. Is that accurate?
That is accurate, Your Honor.
Okay, B being the restrained person was secretly confined, which means to keep the confinement or location of the restrained person a secret. I don't believe that the testimony provided today would support B. C says the person was restrained to facilitate the commission of another felony or to facilitate flight after commission of another felony. And so the felony being an assault with intent to do great bodily harm, less than murder, or by strangulation. The testimony by Ms. Foster was that she requested to be let out the car and that he refused to do so. She's testified that that request took place prior to the point in which the defendant put both his hands around her neck. There was also testimony from the victim, the alleged victim, that he placed his hand around her neck or mouth around some point while she was trying to exit the vehicle to keep her from calling for help. I think that the C is most appropriate. The court will grant the request to add a count 3 of unlawful imprisonment. And that will be bound over to the circuit court along with count 1 and count 2. Bind over date, it's going to be March 1st. You do not need to appear in court on March 1st. That's the date they get to file from this court. Your next court date will be a pretrial in the circuit court. Both you and Mr. Austin will be made aware of that date. Okay, sir? Okay, sir? Do you have any questions?
No.
All right, bond was set at 5,000 personal recognizance. There's a no contact order with a Colette Foster. You're not to be within 2,000 feet of wherever she lives, works, or goes to school. And there's a GPS tether also. Any reasons to address bond?
Your Honor, at this time, I would like to address bond with the new count of unlawful imprisonment. Your Honor, I think that 5K is hopefully inadequate at this time, and I would ask that the court raise that bond to 15,000. Your Honor.
Mr. Austin.
Thank you, Your Honor. I'm opposing people's motion. Mr. Castanon has been out on bond, he's kept in regular contact with me. He has appeared for court. He is on a GPS tether. There has been no allegations of no contact order or that he has violated his bond in any way. He's working, he has children to support. The only prior conviction of any kind that I see for him, Your Honor, was a misdemeanor drunk driving offense approximately 5 years ago. I think bond is appropriately set as is, especially given that Mr. Castanon appears to be in absolute compliance with everything the court has ordered him.
I would agree. The bond is set at 5,000 personal recognizance. That was set back on arraignment January 29th. We don't have any violations or allegations of violations since that time, or any allegations of unauthorized contact. There's a GPS tether also in place for the protection of the victim in this matter. I don't see any reason to increase the bond, so bond will continue as set. Any additional matters for the record?
Nothing on behalf of people. Thank you, Your Honor.
Nothing on behalf of Mr. Castanon, Your Honor. Thank you.
You're all set.
I need to sign for the other case. Copy here.
750349B. That is correct, sir.